Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Delligatti v. United States. In this case, the court considered this issue. Does a crime that requires proof of bodily injury or death, but which can be committed by failing to take action, have as an element the use, attempted use, or threatened use of physical force? The case was decided on March 21, 2025. The Supreme Court held that the knowing or intentional causation of injury or death, whether by act or omission, necessarily involves the use of physical force against another person within the meaning of 18 U.S.C. Section 924C, 3A. Justice Clarence Thomas authored the 7-2 majority opinion of the court. In United States v. Castleman, the court held that knowing or intentional causation of bodily injury necessarily involves the use of physical force. This principle applies equally to Section 924C cases where injury is caused by omission rather than affirmative action. There is no meaningful distinction between acts and omissions, as deliberately causing harm through inaction still qualifies as using force, just as a person can use rain to wash their car by leaving it outside. Moreover, murder, the prototypical crime of violence, has long been understood to include liability for omissions, such as when a parent refuses to feed their child, resulting in death. Interpreting the Elements Clause to exclude crimes of omission would exclude traditional violent crimes from its reach, contradicting the ordinary meaning of crime of violence that Congress intended to capture. Additionally, the word use does not necessarily require affirmative action. When someone deliberately causes harm through inaction, they are employing force as their instrument to accomplish their purpose. Justice Neil Gorsuch authored a dissenting opinion, in which Justice Ketanji Brown Jackson joined. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Thomas delivered the opinion of the court. Title 18 U.S.C. Section 924C, 3A, defines a crime of violence to include a felony that involves the use of physical force against another person. In the context of a closely related statute, we have held that the knowing or intentional causation of bodily injury necessarily involves the use of physical force. This case asks whether that principle extends to Section 924C, 3A, and, if so, whether the principle holds in cases where an offender causes bodily injury by omission rather than action. We answer both questions in the affirmative. Section 924C subjects any person who uses or carries a firearm during or in relation to a crime of violence to a mandatory minimum sentence of 5 years, to be served consecutively with any other term of imprisonment. By the terms of the statute, a federal felony qualifies as a predicate crime of violence if it falls within either of two provisions. Under the first provision, known as the Elements Clause, an offense qualifies if it has as an element the use, attempted use, or threatened use of physical force against the person or property of another. Under the second provision, known as the Residual Clause, an offense qualifies if it, by its nature, involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense. This court held that the Residual Clause is unconstitutionally vague. This court applies a categorical approach to determine whether an offense falls within the Elements Clause. Under that approach, we do not examine the defendant's actual conduct. Instead, we ask whether the offense in question always involves the use, attempted use, or threatened use of force. If the offense can be committed without the use, attempted use, or threatened use of force, it is not a crime of violence under the Elements Clause. Salvatore Delligatti is an associate of the Genovese crime family, one of the New York Mafia's so-called five families. In 2014, a local gas station owner hired Delligatti to kill Joseph Bonelli, a neighborhood bully and suspected police informant. Delligatti recruited several members of a street gang to carry out the job and provided them with a car and a loaded revolver. The gang members drove to Bonelli's house while he was out, intending to shoot him when he returned. They abandoned this plan, however, after seeing too many potential witnesses. At Delligatti's urging, the gang members returned the following day to try again. But, by this time, the police had discovered the plot and arrested the gang members on their way to carry out the hit. The government charged Delligatti with several offenses, including one count of using or carrying a firearm during or in relation to a crime of violence under Section 924C. The indictment charged as a predicate crime of violence attempted murder under the Violent Crimes in Aid of Racketeering, Vicar, Statute, 18 U.S.C. Section 1959A, 5. Vicar attempted murder requires proof that the defendant committed an underlying state or federal offense that constitutes attempted murder. The government alleged that Delligatti met this requirement by attempting second-degree murder under New York law. A person commits second-degree murder when, with intent to cause the death of another person, he causes the death of such person or of a third person. Before trial, Delligatti moved to dismiss his Section 924C charge on the ground that the government had not alleged a valid predicate crime of violence. The district court denied the motion, holding that there can be no serious argument that Vicar attempted murder is not a crime of violence. A jury convicted Delligatti on all counts, and the district court sentenced him to 25 years imprisonment. On appeal to the U.S. Court of Appeals for the Second Circuit, Delligatti argued that a Vicar offense predicated on New York second-degree murder falls outside Section 924C's Elements Clause. Homicide under New York law can be committed by act or omission, with the latter defined as a failure to perform a legally imposed duty. Thus, for example, a parent who intentionally causes his child's death by withholding food or medical care commits second-degree murder under New York law. Delligatti argued that omission-based crimes like these do not involve the use of force. While Delligatti's appeal was pending, the Second Circuit rejected his position in a different case. Relying on our decision in Castleman, it held that the knowing or intentional causation of bodily injury necessarily involves the use of physical force, even when the defendant causes harm by omission. Applying this reasoning, the Second Circuit held in Delligatti's case that New York attempted second-degree murder, and, by extension, a Vicar offense predicated on it, is a crime of violence because it necessarily involves at least the attempted use of force. We granted certiorari to decide whether an individual who knowingly or intentionally causes bodily injury or death by failing to take action uses physical force within the meaning of the Elements Clause. The Second Circuit correctly held that causing bodily harm by omission requires the use of force. As in Castleman, the use of physical force in Section 924C encompasses the knowing or intentional causation of bodily injury. There is no exception to this principle when an offender causes bodily injury by omission rather than affirmative act. Delligatti's Section 924C challenge therefore fails. Castleman establishes that under statutes like the one at issue here, it is impossible to deliberately cause physical harm without the use of physical force. Although Castleman addressed a different statute, we conclude that its holding extends to Section 924C. Section 922G, 9, the statute at issue in Castleman, prohibits anyone convicted of a misdemeanor crime of domestic violence from owning a firearm. As under Section 924C's Elements Clause, an offense qualifies under this provision if, along with other criteria, it has, as an element, the use of physical force. The question presented in Castleman was whether an offense for intentionally or knowingly causing bodily injury met that description. The district court had held that it was possible to commit the offense without the use of force, because the offense encompassed deceiving someone into drinking a poisoned beverage. We disagreed. Our reasoning proceeded in two steps. First, we found it impossible to cause bodily injury without applying force in the sense relevant here. Section 922G, 9, we held, encompasses the kind and degree of force that supports a common law battery conviction. That concept of force includes causing bodily harm indirectly, such as by administering a poison or by infecting with a disease, or even by resort to some intangible substance, such as a laser beam. Second, we held that the knowing or intentional application of force is a use of force under the provision in question. A person uses force in that sense when he makes force his instrument, whether directly or indirectly. So, for example, when a person sprinkles poison in a victim's drink, he uses force by employing poison knowingly as a device to cause physical harm, even though the act of sprinkling does not itself involve force. Thus, whenever someone knowingly causes physical harm, he uses force within the meaning of Section 922G, 9. The logic of Castleman extends to Section 924C. Both Section 922G, 9, and Section 924C cover offenses involving the use of physical force. To be sure, these two provisions arguably use the term physical force to require different levels of force, battery level force for Section 922G, 9, and violent force for Section 924C. But, because both battery level force and violent force may be applied indirectly, that difference is immaterial here. In Castleman, Justice Scalia wrote an opinion concurring in the judgment observing that deliberately causing injury necessarily involves the use of both battery level and violent force. The Castleman majority held that because of Section 922G, 9's particular focus on misdemeanor crimes of domestic violence, the phrase use of physical force in that statute requires only battery level force, which can be satisfied by even the slightest offensive touching. The majority thereby distinguished Johnson v. United States, where this court had held that the same phrase in the Elements Clause of the Armed Career Criminal Act, ACCA, required a higher showing of violent force, that is, the force capable of causing physical pain or injury to another person. Justice Scalia disagreed, concluding that Section 922G, 9, requires violent force, but he made clear that this point of disagreement did not affect the outcome of that case. He explained that intentionally or knowingly causing bodily injury, categorically involves the use of force capable of causing physical pain or injury to another person. And, for the reasons given by the court, that is so even when the defendant causes bodily injury through deceit or other non-violent means. Justice Scalia's view of violent force eventually garnered a majority. In Stokely v. United States, we held that violent force encompasses the force required for common law robbery, which is the quintessential ACCA predicate crime. Common law robbery requires only the force needed to overcome the victim's slightest physical resistance, even if it results in minimal pain or injury. Thus, although the merest touching is not violent force, any force that actually causes injury or death is. We therefore concluded in Stokely that Justice Scalia's understanding of physical force in Castleman was consistent with our holding. By pegging physical force to robbery, Stokely makes clear that even the indirect causation of bodily harm requires the use of violent force. This principle was well established when Congress enacted Section 924C's Elements Clause in 1986. As one contemporaneous treatise put it, just as battery may be committed by the administration of poison, so the force used to obtain property from a person against his will may be applied internally. Delligatti resists extending Castleman's logic to Section 924C. He argues there cannot be an automatic connection between injury and the violent force Section 924C requires because even a small degree of force might injure an eggshell victim. But, as we held in Stokely, the minimal force needed to overcome the resistance of a feeble or weak-willed victim still qualifies as sufficiently violent to fall within the statute's ambit. Delligatti also concedes that it is possible to use violent force indirectly, as when a person tricks another into eating food that is aged to the point of becoming toxic. Thus, the knowing or intentional causation of bodily injury necessarily involves the use of physical force under Section 924C just as it does under Section 922G. 9. Castleman's logic forecloses Delligatti's challenge. Deliberately causing injury necessarily involves the use of force in the sense relevant here. Under New York law, second-degree murder requires proof that the defendant intentionally caused the death of another person. And, it should go without saying, intentionally causing death counts as deliberately causing injury. Thus, second-degree murder in New York, and, by extension, Delligatti's Vicar offense premised on it, is a crime of violence under Section 924C's Elements Clause. Delligatti disagrees. He insists that New York's second-degree murder falls outside Castleman's rule because a person can commit the offense through omission of a legal duty. In such cases, Delligatti contends, the law may deem the offender the cause of the victim's death through legal fiction, but that fiction is not enough to make the person the actual cause. That is incorrect. We have explained that the test for actual causality is whether the victim's death would not have occurred in the absence of, that is, but for, the defendant's conduct. When a young child starves to death after his parents refuse to give him food, that harm would not have occurred but for the parent's choice. Both in the eyes of the law and as a practical matter, the parent's conduct is no less a cause of the child's death than if the parents had poisoned him. Unable to escape Castleman's reach, Delligatti argues in the alternative that its rule is unsound as applied to omissions. An offender who causes harm by omission, the theory goes, does not make use of physical force against the person of another. Again, we disagree. It is perfectly natural to say that a person makes use of something by deliberate inaction. A car owner, for example, can use the rain to wash his vehicle simply by leaving it parked on the street. And, a fugitive can use the cover of darkness to hide by lying still at night. In the same way, a mother who purposely kills her child by declining to intervene when the child finds bleach and starts drinking it makes use of the bleach's poisonous properties to accomplish her unlawful end. And, a husband who deliberately abandons his wife to die in the cold uses the forces of the elements to cause her death. Delligatti's proposed action-inaction distinction has no basis in ordinary meaning. Similarly, we reject the argument that the phrase against another excludes crimes of omission. At most, that phrase requires that another person be the conscious object of the force the offender uses. Put differently, the language against another specifies the required object of the force, another person, rather than, say, an animal, and possibly also the mens rea with which the object must be targeted, knowingly or intentionally, rather than negligently or recklessly. Whenever an offender deliberately causes bodily harm by omission, he necessarily makes another person the conscious object of physical force. In the bleach example, the mother's refusal to take away the bleach is not an accident, but rather a deliberate effort to make the child suffer the bleach's poisonous effects. The mother thus uses force against her child. It would be passing strange to say the mother used force to cause the child's death, but did not use force against anyone. Context also confirms that crimes of omission fall within the Elements Clause. The Elements Clause is a definition of the term crime of violence. When choosing among interpretations of a statutory definition, the ordinary meaning of the defined term is an important contextual clue. Thus, We prefer interpretations of the elements clause that encompass prototypical crimes of violence over those that do not. Intentional murder is the prototypical crime of violence, and it has long been understood to incorporate liability for both act and omission. At the time of the elements clause's enactment, it was widely accepted that one could commit murder by refusing to perform a legal duty, like feeding one's child. As the government notes, this view had deep roots in the common law. Moreover, murder was not the only violent crime that states recognized could arise from omission. Knowingly causing non-lethal injury to one's child by neglect, for example, could amount to common law battery. In 1986, at least 33 states had statutes generally defining criminally culpable acts to include omission of a legal duty. Leading criminal law treatises similarly equated act and omission. Thus, we cannot adopt Delligatti's interpretation without excluding traditional and widely accepted definitions of murder and other prototypical violent crimes from the Elements Clause's reach. If the Elements Clause is to have a reasonable relationship to the term it defines, it must encompass cases where the offender makes use of physical force by deliberate inaction. To the extent any doubt remains that Congress meant for the Elements Clause to cover crimes of omission, the ordinary meaning of crime of violence resolves it. Delligatti insists that his position, that murder is not a crime of violence, is not as outlandish as it sounds. Congress, he tells us, expected crimes like his to fall within the now-defunct residual clause. But, to say that killing someone involves a risk of force is a gross understatement in ordinary speech, rendering the residual clause at best an awkward fit. The Elements Clause is thus the natural home for murder and other prototypical violent crimes, and the unreasonableness of excluding such crimes from the Elements Clause is an additional reason to read the statute as we do. The dissent's arguments fare no better than Delligatti's. The dissent asserts that the use of physical force requires a violent or extreme physical act rather than mere touching or pre-existing natural forces. In other words, disagreeing with Justice Scalia, the dissent maintains that many ways of causing bodily harm indirectly, such as deceiving the victim or slipping poison into his drink, do not involve the use of violent force. This view runs headlong into Stokeling's holding that violent force encompasses the force required for common law robbery. Common law robbery is a crime that may be committed indirectly, such as by slipping a sedative into the victim's coffee. Thus, no violent or extreme physical act is needed to use force within the meaning of the Elements Clause. Not even Delligatti disagrees with that basic proposition. The dissent suggests that, in any event, criminal statutes do not cover omissions absent express language to that effect. No such clear statement rule exists. Many crimes may be committed either by affirmative action or by failure to act even though they are not specifically so defined. New York's second-degree murder statute is a prime example. It prohibits intentionally causing the death of another person without explicitly mentioning omissions. But, because one can cause death by omission, the statute covers omissions. So too here, because one can make use of physical force against another by omission, the Elements Clause covers omissions. Nor do any of our precedents establish that, in the context of the Elements Clause, it is impossible to use force by omission. In Bailey v. United States, this court explained that the word use means to convert to one's service, to employ, to avail oneself of, and to carry out a purpose or action by means of. Thus, the mere possession of a firearm during a crime does not amount to a use of the firearm under Section 924C if the wrongdoer does not employ the firearm to accomplish his criminal end. In contrast, a mother who lets her child drink bleach because she wants him to die uses the force of the bleach within the meaning of the Elements Clause because she accomplishes her purpose by means of the bleach's harmful effects. And, by targeting a particular individual, the mother has taken a specific action against a specific person, not merely posed an abstract risk to community peace and order. As a matter of both text and precedent, deliberately causing injury or death by omission is a use of physical force. Finally, the dissent takes issue with our reliance on the ordinary meaning of crime of violence, branding it an impermissible resort to unexpressed legislative intentions. To the contrary, we engage in the standard task of reading a statutory definition in light of the conventional meaning of the term it defines. Since on this side of the looking glass an entirely artificial definition is rare, the meaning of the definition is almost always closely related to the ordinary meaning of the word being defined. Thus, when the meaning of the Elements Clause is not clear, the ordinary meaning of the term crime of violence is one of the most important factors we can consider. The knowing or intentional causation of injury or death, whether by act or omission, necessarily involves the use of physical force against another person. The judgment of the Court of Appeals for the Second Circuit is affirmed. It is so ordered. Justice Gorsuch, with whom Justice Jackson joins, dissenting. Imagine a lifeguard perched on his chair at the beach who spots a swimmer struggling against the waves. Instead of leaping into action, the lifeguard chooses to settle back in his chair, twirl his whistle, and watch the swimmer slip away. The The lifeguard may know that his inaction will cause death. Perhaps the swimmer is the lifeguard's enemy and the lifeguard even wishes to see him die. Either way, the lifeguard is a bad man. In many states, he may be guilty of a serious crime for failing to fulfill his legal duty to help the swimmer. But does the lifeguard's offense also qualify under 18 U.S.C. Section 924C 3A as a crime of violence involving the use of physical force against the person of another? The court thinks so. I do not. Section 924C 3A may reach many crimes, but it does not reach crimes of omission. As I see it, the court reaches the wrong destination because it takes a wrong turn at the start. Our cases are replete with reminders that, when faced with a question of statutory interpretation, the text is where we must begin, and often end. Today, however, the court whistles past the terms Congress gave us in Section 924C 3A. Instead, it chooses to begin, and largely end, its analysis of this case with an examination of precedent and assumptions about congressional purposes. I will get to those matters later. But first, let's do what the court does not and look to the text. Section 924C 1. Imposes a sentencing enhancement on individuals who use, carry, or possess firearms during and in relation to a crime of violence. Section 924C 3A then proceeds to define the phrase crime of violence as an offense that is a felony and has as an element the use, attempted use, or threatened use of physical force against the person or property of another. Today, the court reworks that definition at the government's request. Now, the court says, a crime of violence includes the knowing or intentional causation of bodily injury, by omission. Under that approach, the government admits, even our lifeguard, whose offense stems from inaction, is guilty of a crime of violence. The only trouble is, nothing like the rule the government proposes and the court adopts appears anywhere in Section 924C. To appreciate how unlikely the court's new rule is, just walk through the statute's key definitional terms, beginning with the word use. When Congress adopted the current version of Section 924C in 1984, the word use meant, as it does today, to employ, to convert to one's service, or to avail oneself of. As this court has long recognized, these various definitions of use imply action, and because use has an active meaning, one does not use something through mere inaction, inertia, or non-activity. What must a person actively employ to commit a crime of violence? The statute tells us, physical force. That is, force applied to the body. Actual violence. This court explained as much in Johnson v. United States. There, the court addressed the meaning of the phrase physical force in the definition of the term violent felony in Section 924E. Physical force, the court held, does not reach emotional or intellectual force, nor does it carry its specialized meaning in the field of physics, a cause of the acceleration of mass. So letting a pre-existing force of nature run its course does not suffice. Instead, an individual must employ force consisting in a physical act. The physical act must also be a violent one. Again, consider Johnson. Because Section 924E uses the phrase physical force to define what qualifies as a violent felony, the court in Johnson rejected the government's effort to equate the physical act required by the statute with the kind of mere touching sufficient to establish the common law crime of battery. Resort to common law battery principles in the statutory scheme, the court reasoned, would produce a comical misfit. Instead, the court ruled, the requisite physical act must be violent, which is to say extreme and severe. And if that much follows when the phrase physical force is used to define a violent felony in Section 924E, surely the same must hold true when the same phrase is used in the same section of the U.S. Code to define a felony crime of violence. Finally, the statute requires the use of force against the person or property of another. Again addressing Section 924E, a plurality of this court has recognized that similar language modifies the volitional conduct, i.e., the use of force, discussed in the statute, and in doing so identifies the conscious object of a defendant's use of physical force. All of which suggests that the statute before us captures only active violent force when it is knowingly or intentionally applied against the person or property of another. Putting these pieces together reveals the implausibility of the court's new rule. To commit a crime of violence, an individual must, 1. Actively, not just through inertia, employ, 2. A violent or extreme physical act, not a mere touching or pre-existing natural forces, 3. Knowingly or intentionally to harm another person or his property. An individual who, as the court puts it, causes bodily injury by omission does not begin to meet these criteria. Someone like our lifeguard may knowingly or intentionally cause another's death by refusing to fulfill his legal duty to act. Maliciously, he may choose to allow natural forces to take their toll. But by remaining in his chair, he does not actively employ even the merest touching, let alone violent physical force. Of course, Crimes of omission like our lifeguards are serious ones that can invite serious punishments under various state and federal laws. But the statute was not written to reach every felony found in our nation's many criminal codes, and the statute's terms simply cannot be stretched to cover crimes of inaction, inertia, or non-activity. Not only does the court fail to grapple with the statutory text, it breezes past the next best evidence of statutory meaning: context. As it turns out, several pieces of contextual evidence, all unmentioned by the court, weigh against the notion that a crime of violence can include a crime of omission. First, consider how informed readers understood the phrase in 1981. When Congress first considered defining crime of violence to require the use of physical force against the person or property of another, legislators recognized that those terms would not reach omissions. A Senate report explained that the operator of a dam who refused to open the floodgates during a flood, thereby placing the residents of an upstream area in jeopardy of their lives, would not commit a crime of violence since he did not use physical force. Of course, legislative history is not the law and should not be confused for it. But the report supplies at least some evidence that ordinary speakers at the time of the enactment understood the phrase use of physical force to exclude crimes of omission. Second, analyzing how particular combinations of words are used in a vast database of English prose can shed light on how ordinary people understand statutory terms. Just such a database, the Corpus of Contemporary American English, contains 47 non-specialist instances of use of physical force. Of those references, all refer to physical contact. None plausibly refer to deriving service from a pre-existing physical force. Thus the phrase prototypically refers to assertive physical contact, punches, kicks, slaps, and body slams. Third, any other interpretation introduces redundancy into the statutory scheme. Section 924C, 3, details two separate ways in which an offense may qualify as a crime of violence. The first, the focus of our attention, is found in Section 924C, 3A, or what is sometimes called the Elements Clause. That provision addresses those felony offenses that have as an element the use of physical force against the person or property of another. The second, found in Section 924C, 3B, or what is sometimes called the Residual Clause, speaks to felony offenses that by their nature, involve a substantial risk of physical force. To the extent Section 924C might address omission offenses, the Residual Clause is their natural home. It requires no active employment of physical force, only a risk some such force might be deployed. Expanding the Elements Clause to reach omission offenses, as the court does today, goes a long way toward rendering the Residual Clause pointless. Perhaps the court considers that outcome a virtue, given that we have held the Residual Clause unconstitutionally vague and thus unenforceable. But conscripting one subsection to do the work no longer performed by another makes a hash of the separate and discrete provisions that Congress enacted. Finally, a look to the broader federal criminal code reinforces what the statutory text suggests. Congress has exhibited no difficulty addressing omission crimes elsewhere, mentioning them explicitly in dozens of provisions up and down the U.S. Code. The fact that Congress knows exactly how to reach omission offenses when it wishes to do so, yet declined to mention them in the statute, stands as one more piece of evidence that the statute covers only offenses involving the active use of force. Where does, or should, all this leave us? To determine whether a state offense qualifies as a crime of violence under the Elements Clause, a court must assess whether the offense has an element the use, attempted use, or threatened use of physical force against another. That assessment does not require, in fact, it precludes, an inquiry into how any particular defendant may commit the crime. Were it otherwise and a sentencing judge could find facts about the defendant's underlying conduct, serious Sixth Amendment questions might follow. Now apply the Elements Clause's test to the New York statute at issue before us. That law makes it a crime intentionally to cause the death of another. Doubtless New York's offense can be, and usually is, committed by affirmative actions involving the use of violent physical force. But the parties agree, New York's offense can also be committed by someone, like our lifeguard, who intentionally causes death by failing to fulfill a legal duty requiring him to act. In cases like that, prosecutors can prevail simply by showing that a defendant did nothing when he had a legal duty to do something. And because a defendant can be convicted of the crime without proof that he used, attempted to use, or threatened to use physical force against anyone or anything at all, New York's offense cannot qualify as a crime of violence under Section 924C, 3A. The court chafes at this conclusion. It emphasizes that Mr. Delligatti committed no mere crime of omission but instead plotted to use active force against his victim. On that much, there is no room for dispute. But neither is there room to dispute that Section 924C, 3A, focuses on the elements of New York's offense, not the particulars of Mr. Delligatti's crime. Some have criticized this feature of the Elements Clause, and their voices could hardly be louder. But no amount of wishful thinking can change the nature of the inquiry that Section 924C, 3A demands. Ultimately, the court acknowledges as much. For New York's offense to qualify as a crime of violence, the court concedes it must find some way to explain how committing that offense by omission requires the government to prove, as an element, the use of physical force. To get there, the court appeals to precedent and implicit congressional purposes. But, unsurprisingly, our precedents do not require us to ignore the statute's terms. And no amount of conjecture about implicit congressional purposes can substitute for statutory text. Start with the court's argument from precedent. The court asks us to believe that its hands are tied by certain cases. Those two cases, the court insists, require us to conclude that knowingly or intentionally causing bodily injury by omission always requires the use of force. So, as the court tells it, even if the statute's terms might suggest a different result, respect for stare decisis compels the conclusion that New York statute satisfies the elements clause. Notice, though, what's missing from the court's account of precedent. While training its attention on those cases, the court neglects so many other relevant cases, relegating them to little more than an afterthought. Where is the case holding that the term use in Section 924C(1) carries an active meaning, implying action and implementation, not mere inaction, inertia, or non-activity? Where is our precedent holding that the same word in the same law normally carries the same meaning, indicating that the term use in Section 924C(3)(a) should be read the same way? Where are our decisions interpreting use in other analogous contexts to mean active employment or volitional conduct? Where is the conclusion that the term physical force in Section 924E excludes its specialized meaning in physics, requires more than the merest touching, and cannot be equated with the common law of battery? And where is the admission that a crime of violence under Section 924C plainly requires the government to prove that the defendant took specific actions against specific persons or their property? Viewing our precedents as a whole leaves little question about how this case should come out, but rather than engage with so many inconvenient cases, the court largely ignores them. Even examined in isolation, the two decisions the court plucks out of the stack cannot begin to do the work the court seeks to impress upon them. Take one case first. It involved a statute prohibiting anyone convicted of a misdemeanor crime of domestic violence from owning a firearm. By statute, Congress has defined the phrase misdemeanor crimes of domestic violence to reach certain offenses that have as an element the use of physical force. The question for the court was whether a state domestic assault statute making it a crime to intentionally or knowingly cause bodily injury satisfied that definition. The court held it did. Because the statute focuses on misdemeanor crimes of violence, the court reasoned, it requires no more physical force than that required to establish a battery at common law, so even the slightest offensive touching will do. And, the court held, the state offense at issue met that standard because it required proof of force in the common law sense. Nothing in this case compels the conclusion that omission crimes involve the use, attempted use, or threatened use of physical force sufficient to implicate Section 924C, 3A. In fact, this case did not even discuss crimes of omission. And when the court spoke of what it means to use physical force, the court spoke in active terms, stressing that the knowing or intentional application of force is a use of force. To be sure, the court observed that a defendant may use physical force indirectly, rather than directly. So, the court explained, when a defendant pulls the trigger on a gun, the defendant uses physical force even though the bullet, not the trigger, strikes the victim. But from that, it does not follow that a defendant uses physical force when he does nothing. Someone like our lifeguard stands worlds away from a shooter who indirectly uses a firearm's explosive force when he pulls the trigger. To the extent this case has anything to say about our case, it does more to hurt than to help the court's cause. To reach its holding that common law battery informs the degree of physical force required by this statute, it had to distinguish another case, where the court held that the degree of force associated with common law battery does not qualify as the kind of physical force necessary to satisfy a different statute. To distinguish that case, it stressed that the statute at issue addresses misdemeanor crimes of domestic violence, while this case focuses on violent felonies. That difference, the court reasoned, indicates the two statutes demand different degrees of force. Here, of course, we face a statute like that one addressing felony crimes of violence, not mere misdemeanors. And if, as was held in the other case, a mere touching is insufficient to satisfy the physical force requirement, it is hard to imagine how complete inaction might fit the bill under Section 924C, 3A. With nothing in the majority opinion to help it, the court eventually turns to a solo concurrence. There, the justice rejected the majority's suggestion that a slight touching qualifies as the use of physical force even under the statute. The common law battery standard, he said, plays no role in a statute that does not reference it. Instead, The author of a previous opinion explained that he read the phrase physical force in both statutes to mean what had been said in that opinion: violent force, that is, force capable of causing physical pain or injury. Even so, the justice concurred in the judgment because the state statute at issue required proof that the defendant caused bodily injury, and, in his view, it is impossible to cause bodily injury without employing the kind of violent force discussed. That syllogism is of no use to the court here. The justice may have claimed that a defendant whose actions cause bodily injury necessarily uses violent physical force. But he did not claim that a defendant whose failure to act causes bodily injury also necessarily uses violent physical force. Quite the opposite. Non-physical conduct like acts of omission, the justice said, cannot possibly be relevant to the meaning of a statute requiring physical force. By rejecting the notion that omissions resulting in bodily injury can give rise to liability under statutes like the one before us, the justice stuck to his view that the phrase use of physical force captures only a category of violent, active crimes, and it is a view directly at odds with the court's decision today. Finding this precedent a dry hole, the court prospects another case. But the court does so only briefly, and understandably so. That case held that the phrase physical force in a different statute includes the amount of force necessary to overcome a victim's resistance. That amount of force, the court explained, does not encompass the merest touching or simply snatching of property from another, but requires more physical contact. How any of that helps the court today mystifies. Our case does not present a question about robbery or purse snatching, and nothing in this case begins to address the question whether a crime of omission entails the use of physical force. More than that, the statements about the degree of force required to satisfy the statute indicate that something beyond mere inaction is required. Unable to ground its decision in precedent, the court retreats, at the tail end of its opinion, to an argument about statutory purpose. The argument runs this way. The court observes that some notable crimes at common law, including murder and battery, required prosecutors to prove only that the defendant, with a particular mens rea, caused a particular result, for example, death or bodily injury, whether by affirmative action or by failing to fulfill a legal duty that required him to act. Offenses like that are sometimes called cause and result crimes. Many contemporary statutes, the New York murder statute before us among them, follow this common law pattern. And, on the court's theory, if Section 924C, 3A, failed to reach significant cause and result crimes like murder and battery simply because they can be committed by omission as well as by act, the statute would not adequately serve its purpose of addressing crimes of violence. I am not blind to the appeal of the argument, but I find it unpersuasive for a couple reasons. For one thing, there can be little doubt about what the argument is: a resort to unexpressed legislative intentions. Congress, the court insists, could not possibly have used the phrase crime of violence in Section 924C, 3A, without intending to capture prototypical cause and result crimes, like murder and battery, long recognized at common law. We have no business entertaining an argument like that. In Section 924C, 3A, Congress did not ask us to plumb the legislative mind or to do whatever it takes to ensure the statute reaches certain cause and result crimes familiar to the common law. Instead, Congress told us exactly what qualifies as a crime of violence for purposes of this law: an offense that has as an element the use, attempted use, or threatened use of physical force. And, as this court has often explained, when Congress takes the trouble to supply an express definition, we are obliged to treat it as virtually conclusive, even, and perhaps especially, if it varies from what we might otherwise understand, or wish, the definition to be. The court offers no persuasive answer to any of this. To be sure, the court protests that it merely seeks to give voice to the conventional meaning of the phrase crime of violence. But the court's focus on that phrase in isolation, followed by an insistence that it must capture common law cause and result crimes like murder and battery, all without any serious attention to the express definition Congress gave us or so much contextual evidence about its meaning, leaves little room for doubt that purpose, not text, is in the driver's seat today. In saying that much, I do not mean to suggest courts may never look to the common law to inform statutory text. Sometimes, courts properly consider the common law when interpreting a term of art Congress has adapted from that old soil. And, yes, we may sometimes resort to the common law when a statute leaves a gap, say, by failing to supply a burden of proof or the requisite mens rea. The trouble is, we have nothing like that here. Before us is an express statutory definition that bears no resemblance to traditional common law terms and leaves no gap to fill. The court does not claim otherwise, nor could it, for we have been down this road before. The government asked this court to draw from common law liability principles to inform parallel statutory language in Section 924E. The court refused that request because it threatened to generate only a comical misfit. The same holds true here. by looking to the common law today, the court produces a serious misfit. At common law, an omission could give rise to liability for a cause and result crime only if the defendant had a well-defined legal duty to act. Think of a doctor's duty to his patient, or a father's duty to his child. Yet the court's reading of Section 924C, 3A, renders the presence of a legal duty irrelevant. As the court sees it, knowingly or intentionally causing bodily injury by failing to act is always a crime of violence. In the name of revising this statute to better track common law cause and result crimes, then, the court, ironically, expands the frontiers of criminal liability in ways utterly unknown to the common law. Along the way, the court hands us another misfit too, this one having to do with our own precedents. The government asked the court to read the phrase physical force in a statute addressing violent felonies to reach mere touchings consistent with the common law of battery. Here, the government goes a step further, asking us to read the phrase physical force in a statute addressing felony crimes of violence to embrace common law cause and result crimes, including battery, where not even a mere touching is required. How the court might reject the first request and indulge the second poses quite the puzzle. If there is some way to reconcile today's decision with this, the court never explains what it might be. Not only do we have no business guessing about unexpressed legislative intentions, even were we to play that game, the court's intuition that Congress must have wanted Section 924C, 3A, to reach prototypical cause and result crimes might well be wrong. Consider a little more closely the concern the court asks us to ascribe to Congress. The court cannot really suppose that Congress wanted us to ensure that cause and result crimes committed by omission qualify as crimes of violence under Section 924C, 3A. After all, omission offenses would trigger a sentencing enhancement under Section 924C, 1, only in the most unusual circumstances. Just ask yourself, how would our spiteful lifeguard use, carry, or possess a firearm during and in relation to his crime of inaction? Really, the court's argument must rest on a different assumption. It must rest on a view that Congress implicitly wanted Section 924C, 1's sentencing enhancements to apply to cause and effect crimes, like Mr. Delligatti's, where an individual uses, carries, or possesses a gun to commit a violent act that causes bodily injury. To ensure that Section 924C, 1, does its intended job of reaching those prototypical crimes of violence, the court goes big. It asks us to accept the implausible notion that cause and result crimes resulting in bodily injury always, even when committed by omission, require the government to prove as an element the use of physical force. But even if Congress implicitly wanted Section 924C, 1's sentencing enhancements to reach cause and result crimes that are committed by act and cause bodily harm, there is no reason to suppose Congress wanted us to mangle Section 924C, 3A to get the job done. Recall that Section 924C, 1's sentencing enhancements apply to a crime of violence as that phrase is defined either in the Elements Clause before us, Section 924C, 3A, or in the Residual Clause, Section 924C, 3B. The latter clause sweeps more broadly. It does not require an examination of the elements the government must prove to secure a conviction, let alone demand that those elements require proof of the use of physical force. Instead, the residual clause reaches offenses that, in ordinary cases, pose a risk of physical injury. And Congress might well have thought the residual clause the more natural home for cause and result crimes like murder and battery, for even if those offenses do not require the government to prove as an element the use of physical force, as committed those offenses typically involve physical force, and certainly the risk of it. Equally, Congress might have had another idea in mind. Maybe Congress did not mean for Section 924C, 1, to reach all murder and battery offenses. Maybe Congress wanted Section 924C, 1, to reach only those murder and battery offenses that require the government to prove, as an element, the use of physical force, or that, by their nature, involve a substantial risk of such force. After all, states write their criminal laws in different ways. And, doubtless, some states draft some murder and battery statutes to focus on the degree of force a defendant uses, not just the result he brings about. Maybe Congress honed in on offenses like that, not all murder and battery crimes, because it thought those offenses especially deserving of additional punishment. That possibility seems all the more likely because Section 924C, 1's enhancements are not the be-all and end-all of federal sentencing. Even when Section 924C, 1's enhancements do not apply, sentencing courts enjoy ample tools to ensure a defendant's punishment fits his crime. And that's nowhere truer than when it comes to those who commit serious crimes like murder and battery. In this respect, Mr. Delligatti's case is illustrative. The district court sentenced him to 25 years in prison, 20 years for his offenses related to attempted murder, plus 5 additional years under Section 924C. But even without a Section 924C enhancement, the advisory guidelines suggested, and the judge was free to impose, a sentence of up to 28 years. The judge, too, was free to depart or vary from the recommended guidelines range to impose an even harsher sentence had she deemed it appropriate. Nor would recognizing that Section 924C, 3A, fails to reach Mr. Delligatti's offense guarantee him some windfall. Doing so would leave the district court free, on remand, to impose exactly the same sentence it did the first time around, or maybe even a harsher one yet. Nothing about Mr. Delligatti's case is unique either. With or without a Section 924C, 1, enhancement, those convicted of serious offenses in our federal criminal justice system routinely face serious sentences and judges amply equipped with the means to issue them. In the end, the court's decision today comes up short on every count. It neglects Section 924C, 3A's definitional terms and their ordinary meaning. It ignores important contextual clues. It leans heavily on only two, ultimately unhelpful, precedents without addressing others. And it resorts to conjecture about implicit congressional purposes that is unconvincing on its own terms. To my mind, none of the court's arguments can overcome the hard fact that crimes of omission do not involve the use of physical force against another. Individuals like our lifeguard who commit offenses by omission may face punishment under many other criminal laws, but Section 924C, 3A, does not reach them. Even if a reasonable doubt remained about that common-sense conclusion, I confess I harbor none. The rule of lenity would require us to reach the same result anyway. For all these reasons, I respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.